What's up, everybody? It's Laurie Gab here, your sister who assists fathers who are going through a child custody battle. I posted a video earlier on a couple of the Fathers' Rights Community Facebook pages about tips on self-representing, and there was a couple of comments, one comment there that had a really good point that I promised I would answer that comment with a video, because as you may know, anything that has to do with family law, and to be honest, in my opinion, anything that has to do with any human thing is complicated. I am the kind of person that I don't see things black and white, and I don't see people as all good or all bad, okay? Now, I'm going to go off a tangent a little bit here, but I was watching something really interesting about the psychologist saying that Jordan Peterson, one of my favorite psychologists, to be honest, and he was saying that people that have that might have a personality disorder are people that see other people as all good or all bad. You know what I mean? Like, they can't understand that people can have can make mistakes, but they can still be essentially good at heart. It's like I either hate you or for who you are, or I love you for who you are, and that same person can feel that way about somebody at different stages of their own life, and that is a sign of a personality disorder. So I thought I'd just put that out there. I found that really interesting. Anyways, as you may know, I am not a lawyer. I am a father's rights defense coach. I have been involved in the father's rights community for 8 years, and during that time I've been gifted lots and lots and lots of stories and cases of fathers who have succeeded in the child custody battle and of fathers who did really badly. So it is me just passing that information on to you. What you do with this information is your responsibility. I would highly, highly recommend, and always will remind you, to get professional legal advice by a qualified family lawyer. Not just one, go to at least a minimum of 3. I knew one dad who, by the time he spoke to me, he'd gone to see 7 different family law lawyers just to hear, not just to hear the different opinions. A lot of them had the same legal advice, but he needed to click with them. He needed to feel comfortable with them. I've known a lot of fathers that actually, they do lawyer shopping, proper lawyer shopping, so that they test that lawyer and they go in there, with the mindset of testing that person, that legal professional, to see if that is the right person for them. And they will then call me and tell me how that interview went, and they'll tell me themselves that's not the lawyer for them, or that's the lawyer for them. So that is a really important thing to do, to go through several lawyers. If it would be a miracle that the first lawyer that you go to is the right lawyer for you. It would be a miracle, and miracles do happen, but very rarely. Okay, so keep that in mind. Anyways, close that one up. That took about almost 3 minutes, but I was talking about that personality disorder thing. So anyways, the comment that was posted underneath my self-representing tips is, what about section 60cc 2b? Okay, now section 60cc 2b, because part of self-representing in family law is that you need to know your Family Law Act. Now, it can be I'm not saying go ahead and read all 121 sections, because that is just way too overwhelming, and it takes lawyers 6 years to do that. No, honey, just read one. Just get to know one, and that's section 60cc. If you're in WA, it's section 66c, Family Law Act 1975. That's the only one you need to know when you're self-representing. You can go further if you want to, but just get to know that one off by heart. Now, in section 60cc 2b, over here, right, this is actually the judicial paper from the Western Australia Family Law website. I've had this paper for a long time. I printed it out. It's pretty much section 60cc or section 66c, and you can write in there if you want to write by hand. My writing is horrible, so I just type it, and you write how it relates to your case, right? But very important note is section 60cc 2b. 2b is what makes or breaks a case, and 2B can cause a father to lose all custody or can cause a father to gain full custody. So do not use 60cc2B, especially if you are a father, because remember, you are not equal to the mother. I wish you were. I'm just a messenger. I wish you were, but you're not. Does that mean you have no rights? No, that's not what I'm saying. I'm saying that the way that you play this game, and I hate saying it again, and I hate saying that it's a playing a game, but there's really no, I can't find other words for it, right? That are simple words for to explain this whole, thing. The way that a father is going to play out this game, or the way that a father is going to plan out his strategy for a family court battle, okay, is going to be significantly different to how a woman or a mother does it. So one of the biggest mistakes is that fathers go in there and assume that because she's talking shit about him on affidavits, that he needs to go and do one better and talk more shit about her. And say, well, if she's going to say lies about me, I'm going to write, and type up, the truth about her. The courts don't care. And they do not like a father specifically, talking shit about a mother on the affidavits. They don't look kindly on it. And it only, what that does is that what's happening there is that the father is playing into her game. And you can still turn that around, okay? But it would mean that the father has to sacrifice his ego immensely to be able to turn that around and get the case beginning to work in his favor, okay? Because it would mean that he would have to write a very, very different style of affidavit that has an apology to her and to the court for talking shit about her on paper. Now, whether you are sorry or not, it doesn't matter. You just got to write it on paper. You just got to fake it till you make it. The main thing that you got to understand as a father is that A, you're not equal to the mother. B, there is a bias against you. C, the game that you play is going to be very differently. What the courts want to see from a father, from a man, is that you're the bigger and better person, that you're calm, cool, and collected, that you're humble, but yet strong. Okay? Now, getting into the mud with the ex when you're talking shit about her below average mothering or below average persona or personality is playing her game. And that doesn't work for fathers. So you're asking, well, what does? What works for fathers is the fathers not entertaining her bullshit and focusing on the relationship between yourself and the children, between the father and the children, and focusing on section 60cc of the Family Law Act and answering those on an actual affidavit. And lawyers don't like doing that. Lawyers don't like doing that because to them it's beneath them to put section 60cc, because the legal community, the judges and all that, assume that the lawyers would know that off by heart, which is true. But we're talking about your case here. We're not talking about the lawyer's case. This is your life. It's the lawyer. It might be the lawyer's case, but if you fired that lawyer and you needed to self-represent, right? It's your life. It's your case. So it's important that you put it in there. Oh, but the affidavits need to be factual. They need to be factual. Yes, they need to be factual, but they also need to give an explanation of who you are as a person. You need to write in a way that's going to make the courts think of you highly as a person of humility, as a person of strength, and as a person who's not interested in talking shit about the mother. And you would literally have to say that in your affidavit. I'm not interested in talking negatively about the mother of our children in this court battle. Even though she has said false allegations about me, I am not going to entertain them and try to respond to those by saying truth about her, because it would mean that I would have to speak negatively about her, and I am not here to do that. I am here to be a father to my children. To our children. I'm here to have an amicable co-parenting relationship with the mother. And if I had to stoop to that level and get in the mud with her, and obviously you don't want to say these things in affidavit, but you can if you want, because you're trying to tell the courts you do not want to be fighting like little kids and treating the courts like the school principal or the teacher who's going to strip her away from her parental rights and give you custody because you are of the opinion that she is a below average mother. It doesn't work that way for fathers. Section 60C2B only works, okay, which means, I haven't even said what it is, sorry, I got off on a tangent a little bit. The need to protect the child from physical or psychological harm from being subjected to or exposed to abuse, neglect, or family violence. That is section 60C2B. That, there's a note underneath it that says that overrides all of the other subsections in there. So the first subsection under section 60cc says the benefit to the child having a meaningful relationship with both parents. So that's one of the first things that the law says, and the law has said this for over 40 years, that a child should have a meaningful relationship with both parents. That is at the core. But the next subsection says if one of the parents is so dangerous, right, that there is a greater need to protect the child from further psychological harm or being exposed to abuse, neglect, or family violence, then under that section, that parent can take full custody. And that only happens specifically for fathers. If you want to use that section in your affidavit or in your case, it has to come from expert evidence, not your opinion, not your recordings, not the text messages, her crazy text messages, because the courts understand that when people are fighting, and again, you're not equal to the mother, they're going to let her make a lot of mistakes, say crazy things about you via text messages, via video recording. It doesn't matter. They're going to let her get away with all those things way more than you. That's why you don't play that game. That's not the way that you handle your case. You're handling your case the other way. Your job, when fathers try to desperately convince the courts or desperately convince the experts that she's XYZ and that she's a below average mother, that tends to backfire on you. That tends to backfire on fathers. Because it makes you look like the obsessed person. It makes you look like you're the problem. The way that you try to convince the courts of anything is by writing in a way that is in between the lines, like you kind of mentioned it. For example, when we had a separation, she ended, at one point she was admitted to a psychiatric hospital, and I was left with our child and look after our child for a month or something like that. And that's it. You don't go to say, and I was scared and she did this and blah, 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 and she didn't wash the dishes and she hit me and she did it. Even if she was an abusive partner, you do not need, as a father, you do not need to bring that to the family courts, because they don't appreciate men being the victims as much as they appreciate women and children. That's not the angle that you take. And if you do want to say something about her violence in the past, you need to deal with that in the magistrate court. They expect you to deal with that in the magistrate court. As a father, now a woman can bring it to the family court and they'll listen to her to an extent. But as a father, you have charged her, you have put an intervention order on her. Because if you're trying to bring it to family court without even doing those things, you're not going to sound credible. And you're not going to sound like the kind of person that wants to share custody and that wants to have a good relationship with her. You're going to sound like a person who wants to fight, who wants to have serious conflict. And a lot of the times, it's the lawyers who will encourage you to fight and put conflict on paper and have cold-hearted affidavits and have cold, strong, aggressive emails to the other lawyers, because the more conflict, the more money. And then they mess up your case and your life and your kids' life. And I am fed up with these freaking lawyers. But anyways, not all of them, but don't get me started. But anyway, there are several cases, and there is a very, very important precedent on ostlee.com. So ostlee.com.au is where you find all the legislations, you find all the acts, and you find past cases and the cases that have been posted, the cases that have gone to trial, because a lot of cases don't end up in trial. I know everybody thinks that the case is going to go to trial, but there are a lot of cases that don't end up in trial. Sometimes you get to the trial and it might get negotiated on that day, and then bada bing, bada boom, you didn't need to go to trial. You don't have to go through all the trial. But anyways, if a case ends up in trial, it will be posted on Ausly. Now, there is a very important precedent in there. And I actually know of a father, and I helped him personally, okay? And he achieved full custody of his child thanks to Section 60cc2b. But the way he did that wasn't him trying to do that. It actually happened because the mother, having a personality disorder, having worked in child protection industry, thinking that she had all the entitlements, all the rights, and thinking that she knew how to manipulate the system. Now, it's very easy for women to manipulate child protection system, and it's so freaking easy for them to get child protection to write any letter against any man or in favor of them. They don't even have to see any evidence, and they will be judge and jury, and they will go against the man in a heartbeat. But that doesn't work in the family courts. Now, that's the reason why, in a nutshell, the family courts are experienced people that get paid a lot of money to deal with these cases. The child protection industry are very inexperienced people who don't last very long working in there, so they have a high turnover and they don't get paid very well. Okay, so anyways, this woman kept trying to convince the child that the father had sexually abused the child. This woman went as far as to take the child to be examined at a hospital well after the alleged, sexual abuse had happened, as a way to try to get evidence against the father. Now, this is where she messed up, and this is where it works in the father's favor, when the father is not trying to desperately get people against her, that she's doing it herself. She did not take that child just once, not twice, but 3 times. Because the first people that told her there's no evidence here to suggest, sexual abuse, they go to the orange team, the sexual assault team. She took that child over and over to try to get people to side with her. And when the first people wouldn't side with her and told her there's no evidence here, this did not happen, she was like, well, I'm going to go somewhere else because I need that evidence to help me in court. And when the father subpoenaed that evidence and the courts told her to stop doing that, she went and did it anyway, because that's how narcissistic and mentally ill these women are. They think everybody else is stupid, and they think that they know it all and they can manipulate. It backfired her big time. Now, the father was asking for 50% custody, but when she kept trying to convince that child that the child had been sexually abused by his own father, and by her own work, she was the one that created the expert evidence against her. And the father was able to get that evidence via subpoena and was able to show the judge, this is what's going on with my child. And because the Section 60cc2b states that to protect my child from further psychological harm here and from being examined by more professionals, because she wasn't going to stop and she was going to keep going. And she said, I will find somebody to side with me, because I know that our child was, sexually abused by the father. And what had actually happened was that the child didn't have a very good diet, and that he was constipated, and that he had a bit of, that the constipation caused a bit of tearing. And even though she knew that, she just wanted to try to use that as a way to say that it must have been the father years back that did it. Crazy. And so the father had to amend his final orders and say, because of the evidence that she's created before the courts now, I have no other choice but to go for Section 60cc2b and get full custody of our child. So that is when you use section 60cc2b. Go check out Ostley, the case is there. That's a really good precedent. Remember, expert evidence, it's better when you're not trying to convince. If you can't find, if there are no professionals that are going to side with you, and the less you try to convince them, and nobody is seeing what you see, drop it. You have to try a different angle. Okay, I hope that helps.